Ekosiisen jumedi no aso go so awutie na Sempa FM so eni yada mo nyina asesa mama kwa ba bio me dey your say bon so me ka say lawyer Henry Nana Boache ewa ha ono ye one of the spokespersons for the second respondent in the ongoing election petition case. Supreme Court has set 4th March so mo the final judgment no ebeba and for more mo follow no munim baby a if yaba be do baby asisia yaba ababa be droi interlocutory applications be brina na aba ebinom court ne gitum ebinom court na ebo etu eguye ene de abedu bibia yaba ababa be droi nana intima mamemfa won shase na where we are now. At all saying,
Obi Medasi, because a better Yamias and baby or dear bedroom. A dear Maniaji who ye pan is a Obekaya 2013 presidential petition. No, a travel
8 months,
8 months and some days. Nti ene ohwa na Supreme Court nani abrese asemi no
Ekosiisen on Asempa
Ghana fo nyina no bia ehu no ano nti so far metimi akasa nyi bia na atwa be busumi be mienu anesa ohwe ebre nso a court dia ba betu dwa se ode nanu asem temu na nkasa beba na say ebe busumi mienu ni ekiri kakra bi which uhesi ya 99 mu is well within the
3 months
the 3 months na ewu no nti nyame adaroma ene nso bia kana asem awie obia bie na asem ani ene obia to na asem mu nti obia nso afale ni closing addresses in fact me gidi is ene na court ne share eye petitioners
say on file in there
closing addresses in ano embe to court enim ene enti baby ayadru de megidi ba nene ochene kono court international bi ma gise busumi eba be wura mu da to so nan court ka se obetransi Thursday de ba to hwe mu na ye openi ayene ye contempt case
charge no
eno a ochire se yampa obi onim de ewiase nyina ye fom apa cho kama ni okan no wanye ni ye nyina no yetime fom so ye ho enti eno ano no kwasem ni obi ana mebu ni pa but eno ano ebu ana mo
Ekosiisen on Asempa FM
so enti eno ne emse court betnase eno Thursday na emse eno ana court kwa no hwe asomom kan no say baby a ye chichire abo no
ehwa ne
yesane no enti baby a okoya oka ensem a efi se gu court ho fin a won so wagye atum no ene sa akọ na ne kokase wankase yi na apacho eno anso na efe ohwese ya lawyer from penifo
Frank
Davis ka ho bi Gabi Asare ocheda komo so ka ho bi ena omo society ni aba be gina na chi a omo show that support timi kan bia ye nyina no ye ba ko enti obi ubusa so far no baby a ya ba be dru ni eno kra ohwemu a reviews be miensa ena akoso review ba ko edi kan ko na ye interrogatories na yes someone on person komode pimpim isi na court amakwan na no no ko ho review na court no en empenifo en nkunu na sabugu ye review atoso mienu na ye bra court ka se emra bia no hono ma ehye managing mensa se on betranda kemu enti eno so no omusa ko review na empenifo nkunu na no sa ebugu ye na nanu ye idea o de shede o de kotu court ni mse
omu case ni bi
omu case no eni a court anti
Asempa FM
o hwe ya eno party through na ya ba bedru say enti obi obusa ya na eno an megidi se be konsem ni mu enti so far so good na ade ba ko a asem ni nyina ne be pie ya na ha me yi ene o hwa petitioners o mutaka kan asem bi in the interest of justice,
yes,
and a fair hearing. In the interest of justice and a fair hearing. Obi, omuntimi ma particulars biya chese ampa fair hearing yemfa ma homo. And omuntimi justify asem no mo kan. Obi ebra wo de wasem ekoto court anim. na why am from so cry or cratenim court Emma Quine Emma Sam from so no could see na the buy. Was our buyer now had this interrogatory buy. What the buyer no so court said you and a court no some buy. If you and now court cast and Kenya yam file a witness statement, ya dance the crata.
Ekosiisen on
Asempa FM. And a mamma application. Stay of proceedings a buy. It's a no court and no credibility. Emma court crab free case. Omo to me crow, see I know says a court, a man she. Se fan crat table to yenim. Na one farmer. Court 8 me was in 8 me to us in. Then so humobro any kwanya court AD any in the interest of justice or more can. Court say yamamu kwan biom. Mo fa mo witness statement embra. Ni to asem no so eno mo di review ni by court say tie. Ebra mo bie mo asem ni ana mo sa bo nkurukra no. Mo ka asem be fra dance fo enum. Mo frame you court na bisa say mesre o mo wi ana na ase da bi. Aka nipa ba ku bi na impomodin hu nsɛmti. Mo pese mo ne a judges fo yi ene a lawyer fo no kokokuam na mo kodi nkomo ba. Mo kokokuam kodi nkomo na ebra nanka yama order se obi han file na witness statement no. Yesama mo kwan e ma mo sa file witness statement for one additional person. Rojo Metununu. In fact, a kwan ye fast so ye no kra no. Na mo se opani ni sense ni pomu nya dinti no ntimi court dem. Ye de abafu mfidie bi ko ni fie. Ekofa TV no ni ade be bobo.
Ekosiisen
Asempa FM. Emma eye video calling conferencing Zoom ye de fa so bi na ye tie no mu nsem. Ye wie ne se busa mo se mo wie mo bibia na mo amode mo pem. E ka se mo bom nkura wie. Mo ye bibia wie. Nti se wusai etwa woni be kato se wanya fair here na. Etwetwe aso because obi a wo hwe TV no se ensem ma kan look. Etoda time management, any case management. Court credit to make us obi ankasa ebia simedu num simedu asa. Opani chachu gina na so so kasa. Don hwere ni akiri bi wa don hwere mienu. Ni nyina court no aso ni nyina mu.
Asempa FM.
So for me, it will be improper for anybody to say when you fair hearing no asem mu. Asem bia mo de ba bia application bia mo de ba to court ni bia court tie. Empokra ebra court ka say yem file closing addresses no. Eye petition is your man file because no so say another review bia saba. Nti omo do ma dwem no e bia review ni koye mo a it may change the nature of their closing addresses into nya dia omo do ba. Inya court na tie no.
Ekosiisen on Asempa FM.
Musa kwada de sede be to court ni say ka court mamu break kakra na nka mo file mo closing address na court mamu ne so by close of the mo san file court say team eti eno there for me as I said no it would be improper o menya fair here na biem sa in the interest of justice I was some many better that come no in the interest of justice fair hearing no enya applicable only to the petitioner. Fair hearing no applicable to all parties involved. All parties involved. And you need to back on. It is a obika fair hearing. Fair hearing. The right to adduce evidence, no, a part of fair hearing, and the right to remain silent is also part of fair hearing. Justice enso ejina mraso pepepe yo hoyi ye de mra na ye
Asempa FM.
enti obi ntimi nka say in the interest of justice na ya kana sakeke ne eja ho in the interest of justice
Ekosiisen
pepepe yo hoyi
Asempa FM.
eye mra ene jina so mra nso ene didi asemi enti ebi wo hono ma court be kan asem bia na owra ho because court nsem nya no ni beje because uko na nka wo botaye ni suade hunu ebia we nya ne saa
Asempa FM.
we nya ne saa eno enkyere se we nya pepepe yo we nya atentene eno enkyere se justice anya adwuma da bi wasma wo do call no Ena wo gidi say ahwene te won pani anim a ebi nyirenti wo do company fo no so ahwehwa no mo de asem na yede ato ne da. It means the issue of fair hearing and justice no, for me it is improper. Court na ya de papa, court na de mra ya adwuma, court no e de nhyehyeye da ho ya adwuma, court no fair hearing obi bia right waso mu yi kama na obi obehwa enra enkomudi e course no wo hwe eniema be enuma na nsia ena na
Asempa FM
a petitioner no ogina so we ni review
for
na
application for review
grounds, no.
Okay.
Ekosiisen on Asempa FM.
Almost say court no was per inquiry section
Ruling, no?
Yes, section 72 of the Evidence Act will be per inquiry enye adekesi bia say court na bu asem no bu na nkemra bi wo ha na se ose nkohwe ida se obu na ni aguso ida se wo ye free ho no common law principle I free emramu ne bai ene nyanso ya so mu ha nti ne omo chenya ne se section 72 no court no amfa na ni anhwe ni yi kamia kwa se court ebu na ni eguso na section 72 obi me read actual
72 of the Evidence Act.
72 of the Evidence Act.
I mean, when you met here for this lawyer Baba Jamal Baba Kayensa
senior spelon that
lawyer Baba Jamal Akwaba it's saying Edanyamiasi. Nana Ntitwaso.
Section 72(1). Subject to the discretion of the court. Any beams would mamma fan to just say section 72. A brana omu argue case to reopen. It never appeared. Okay. And the omoba review in Omodiaba. Subject to the discretion of the court. In a civil action, a party or a person whose relationship to a party makes the interest of that person substantially the same as the party may be called by an adverse party and examined as if on cross-examination at any time. At any time during the presentation of evidence by the party calling the witness. But opinion chachu
at any time during
the presentation of evidence
by
the party calling the witness.
Okay.
Hwenya ono no ekoti wo ono statement of case ni the support sa ni motion exactly or say baby ehu hia ye no at any time during the presentation by the party calling the witness where evidence na film yen ya lawyer for penifo ebra omuhu we no ewo sa omunkrata enim no na eyo mo se ebia a refuse itimi isi because evidence ni very operational presentation of evidence very operational openini say jina na so na okuta the act itself na okotie free mu no o say evidence ni free mu obi mari kuntia because the moment with the presentation of evidence by the party no it means you have to do this whilst you are still conducting your case. Ebra ugusu a udi wasem no wabie wasema ubu nkuro no ana this section 72 ni applicable. Ebra uba no bu nkuro awie ubu nkuro wie a uba na wo sai akotia. So for me openi chachu misled the court, and that is what our lawyer Kutampa even said. That usha because if you say du krampanka uja honi free muno ebia refie yenya etimie typo. But for you to stand on your feet, make reference to this provision not once, not twice,
Ekosiisen
several times,
on Asempa FM.
and at times I will make reference to be an uja presentation of evidence.
Asempa FM.
Yet, what the Abba share as part of the grounds we say, court now for the Niashaho, and until a cause grave miscarriage of justice. It is not true. Rather, no. Osha, from this conduct, no, you rather sought to mislead the court. Obi Ebim, so Osha, even the same section of Kana was subject to the discretion of the court.
Yeah.
It is not automatic. And also court Sashim. It's the idea no, already no, in your earlier submission, you never made reference to it. The provision itself, subject to the discretion of the court. And then, usaija an essential, very operational word. Niyama meaning at what time ubetimi ayusi set this provision. Usaija and also free. So how then can you make this your grounds as ground one?
As ground one for application.
Exactly.
For point number 2 in the trust, Namin Kobabaho, Nama Science.
That's yes. Good. Point number 2, ruling Ibium. Almost say the ruling of the court was in fundamental error in subjecting statutory provision in the Evidence Act to the provisions of subsidiary legislation, especially Order 38, Rule 3E5 of CI 47, amended by CI 87, and has occasioned grave miscarriage of justice. Obi, Osashe ground 2 na omo kasafa titri wushapana omo kasafa section 26 of the Evidence Act. Section 26 kasafa estopel.
Yes.
Right. Conclusive presumption. Okay, Obi. Eno no say Obi me no won hihye bi. Ana say me ne yoye. Me kasa America. Madani nyema bi ania ma wo hu se no. Dwumadie se na me ne wudi. Ama wo so nya gidie wom. Enti gidie a wonya awom no. Ama wo so no wo de wo ato so. Enti ntimi ma be ka say oh me kra o ade a me na me boa da bi. To a conclusive
Ekosiisen on Asempa FM.
Enti wo de ba omo asemu na omo chenya ne say Maame Jane Mensa eye affidavit sa o de beto court anim. Ensema wo tintim e wo mu no. Wa tro wo mu say se ebreba obekaya interrogatories in time no. Se ebreba na so betra da kamu a ensem ni bi wo mabusabusa no they can still access obetimi ayi no. Ye minimum NDC for say titri petitioner ne say o de ne hoto sa asem na Madam Jane Mensa kan on affidavit nim. No, because before you can rely on that provision, and almost you say rely on that provision on two fronts. First one, I meet me. Almost say my men can be conclusive presumption. And to once my meeting teams and cratanity, almost hotoso. And to now fear almost say my men never bad that and also my men casa for the minya maybe. And just a court a shen maneba. Obi, any pa. Oka say my menembra. Who apply for interrogatories. It is not as if I mean affidavits no. Ne krata no. I will say a brebana so betra de kama. Obetime ya no no. And I will announce it to court say my lord, in view of and some I mean I can a year ne affidavits muntino. So we are withdrawing the application. In sene be a between a bra obijina da kamna ya toso busa. You actually pursued the application to its full logical conclusion. You argue the case out. Would the actually echo mu be away? We are caught and no assembly no crampo no. Obi, do you know what you did again? Almost a call for review. Because Obi, you need to demonstrate to the court, say, what they want to so. Now, in this case, you never believed what the person said, even if you want to rely on it. So, how did you demonstrate the reliance? When with disregard the affidavit, and rather you pursued the application, you argued your case out, and a court no bogu and also court review. Obi, the second leg almost depending on how we know. Ah, Moka said that. I'm maybe Hona. The opening sentence of a year section 26. I say, except as otherwise provided by law, including a rule of equity. Except as otherwise provided by law. Thomas Momo can say, "Washe order 38, rule 3E5 now." Near can say, "Obi the witness statement ebe to court him." Na say, "Nipa no am fa no ho an two witness statement because ebi am ma testifier." So witness statement e betimi afa no mate adanse. Here see evidence. It's in your motion say because court AUC order 38, rule 3E5 no. Court in epeja CI no over a statutory provision. How can that be? Because the opening sentence alone gives room for application of other laws. Because in this case, specifically, we are talking about witness statement. CI also Kasafa witness statement. Then your argument is that we have elevated a CI far above an act of parliament. That is never true. In this case, even the opening statement itself, except as otherwise provided by law, say mrafufu bi wo hono mo a o say kan say mu hu de a mrafufu ne de any CI o kan article 133 133 ni say in review applications rules of court be determine grounds of it how abisiaba rules of court committee in suna de adeba entini CI no mra. We had two fronts now, they sought to even depend on. So, on ground being no crampona. It's still wobbling. And they say, good form, Bubuja. Ground one is gone. Ground two is gone. Also, young China, Omra, Muna, Yentwas.
Oba, I'm so Abba, Baba Jamal, Ababa Kayan, Sa, studio, ha. Ekosiisen, higher, Sempa 94.7 FM. Ma, men Kai mo say, Nescafe Sweet and Creamy and Swear Boy, one Ghana city per Unya, Bibia will be here, and insure eshe, kakra, the dead, now what to a gum. If you love that tantalizing aroma of coffee, the Uhia and Nescafe Sweet and Creamy, but more than a mouse and kebi. One Ghana city pe na unsu enyebi eto enom. Nails and Locks Enterprise so say omo number one dealers in top quality security locks, padlocks and steel doors for your homes, shops and offices. Now we also stock the very best of stainless steel and full brass products ranging from mortise locks, security padlocks, hinges, tower bolts and a washroom locks. Ni na obenya bi ewa yen ho etumi ato. O frey enso a obeba ababa beto nioma atimi agye futuo ankasa expert advice on products for new project and renovations. Ni na obenya ewa yen ho. Yesan so free installations for yen bulletproof made in Turkey steel security doors no ever be install ma kama. Yesan what discounts so available when you buy the main lock and after a time of 50% discount on all other accessories like door hinges, stoppers, tower bolts, and more. Your Accra, UTC, opposite Bank of Africa. Ubit my friend was 0249 232329. Na only edin como 0249 232329. Your website is nailsandlocks.com. Almost say affordable, guaranteed security. Simamienu na afi lawyer Baba Jamal eni yeni nkomo.
Hey! Wow. Why is everyone speechless? Because DSTV is offering you the same mind-blowing entertainment at a fraction of the price.
Huh?
For a limited time only,
Ekosiisen on
Asempa
FM.
and installation plus 1 month of DSTV access cut down from 229 Ghana cedis to just 199 Ghana cedis. That's ridiculous. Before it's too late, get the best for even less with DSTV. SMS 1731. This is your moment.
Wow. Aha. Adania Brochire.
Global lighting for lights. Any home accessories papa ne ball from Sunu. We're providing lighting solutions for Ghana more than 20 years. We're pay no environment at society for fair. Europe Niema, the highest standard in terms of quality. Ceiling lights, outdoor lights, chandeliers, wall lights, compound lights, LED panels, spotlights, braces and surface, switch and sockets, wiring cables, and the Kekahua, electricians, and the contractors at the year one projects no, or to free global light.
When are your friend ultra modern?
Papa B, street lights nipples now, water one near ma, was sunny ama with technical advice and after sales service. Spentex 027 900 3066. Only textbook market div anymore. Osu Ari, command phone for 0302 769 382. One my coffee house in the div anymore. And the Kumasi 0278 744 886. One Palace Mall and the div anymore. Santas runabout.
Global lighting.
And Kania Pahifi. And I was so ne macho.
Ekosiisen on Asempa FM.
Hey, na malaria na fahia mutu awaria momoni agisa no.
Adom malakio mesha ewo hwe malaria ent na yeso nche.
Ye kwaya test e biwo mu pe enyenum adom malakio mixture. Eni gina malaria body weakness yo tiredness yo hwim ye nyina ho atoye ntam kura.
Na adom natural tonic a esisi ha yisu ye.
Adom natural tonic nenso. Ye num to ya ye ntimi nidie. Eno na yanum bi edidi a ye ho tayen sa no.
Adom natural tonic.
Menya anemia na mentimi nidie. Menum bie bono me taisa.
Ah, mo hwa ye fe pa ene ya mepe biato.
Ni nyina apemfo abatan ya wo mo manufo ne nkwada wo ni fie dunsia nka ho. E wo pharmacies chemical ne herbal shops. Dodo a ko dependable herbal home, Medina New Road, Greenhouse. Anane branch e waka so opposite there to International School. 024 2223 555.
FDA ahwehwe sa ejedi nkrato emu age atum se eye.
Wakoye passenger ni owo to mikasi pa sa obabua am ye sika nkwanhia no kwan e wo ya kwan so eni nti sa oti hyen mu na se o hyenkani no okọ America tente wano monsa oyifa ho wo bia eni kwan so wo yesa ana se wo kasa o
Ekosiisen on Asempa FM.
kasetia na se unhu so hyenkani no nani kuma moma ni nyina na onye na home eyam no mienu asade si ye boye nkwa ho ban ewo ya kwantempo so ni esika nkwanhia no kwan sankratoyi National Road Safety Authority in the Debra War arrive alive kodru jojo medase.
It's your life, arrive alive. 89. Hey, it be 89 pay. Go TV ahead there. Go TV is giving you a special independence offer. Get your Go TV decoder, Go Tenor, and 1 month plus subscription at a discounted price of 89 Ghana cedis pay. Now enjoy over 45 local and international channels today in digital clear pictures. A month for Duado, where a special independence limited offer. Intimates like a cra. Kwaju decoder for the best in entertainment. Visit any Go TV accredited dealer or SMS Go TV to 1731. Go TV. Love it.
Color Party, Adum FM, Asempa FM, Adum TV, AdumOnline.com. From Color Party this year, ya to mun kine kra.
Ekosiisen on Asempa FM.
Uber swap fridge, mobile phones, any achadia ahudu bebre. Color Party.
Asempa, upa asempa tia, uti uni radio mupa odem 94.7. Asempa FM, oh yeah, do papa. Asempa FM, everywhere you are. Asempa FM, everywhere you go. Asempa, hey, all talk all day.
All talk all day Asempa FM. So ni Ekosiisen dwumedie no asogoso awutie no. In the background no mobete a lawyer Baba Jamal ne lawyer Henry Nana Boache debate na shase off air, Dada. But let me hear from lawyer.
Which minute nanka ebeboa?
O say no, manenkasa.
O baso do late. Who could yes?
We do late. We better we do okazan makatan. O me do me okazan. Okazan 45 minutes. Me bakasa say better makasa. Better say makasa. No better makasa. No better makasa. Better makasa.
Baba Ekosiisen my edikan. Maybe yaba be do ni.
Edikan. Constitution kasa. Law bien kasabium. We constitution fiwa. No about acts of parliament. And so about CIC as subsidiary legislations no way knows what man say. Enti when me say among 40 assessor. Ye court say ye challenge petition. Ye court no. Yamfa yen ye figures and court. Let me establish that clearly. So any question about moon figures was no, that's not arise at all. Ye court on no court to my end 5 issues. None of the issues and the kase moon figures moon famra. To a moment time when Tom kase moon figures when they should know that it's not part of the issues. They touch me, you know. Nanabi can be said, ye court crano, in trying to demonstrate how the court had been fair to us, no. More court to crano. But the mistake from so many court no Saturday. This is something that happens in normal daily practice of the law. In fact, ne ABCO friends as a man's court. And then, why the mount? No, why correct it?
At the discretion of the court.
Of course, discretion of the court, because those typological mistakes, no, are something that happens daily.
Yeah.
And court say, open so 5 children. Maybe a wire of 5 no worse, and a watch in figure no wire no 4. Court no say on the face of it no a mistake, and they will let you collect.
Okay.
And the more in creating impression say funsubi ebinsi omremuda antina court no guys will introduce it to demonstrate is just the justice or the fairness to us. Ye court no ye applications say mameno in the first thing you apply we serve a notice to admit facts and when fien facts be or who send admit when fien in the win someone will make sure I mean to those interrogatory inspections and also someone catch on when fien because say mameno ye need asem no and then you may be where normal thing the man no asenko onya no ko yi ano ebian applications in kabebiri nka no so kabebiri ama but what the man on interrogatories are several, you know. There are several CPC some questions be. And a wow say, who the application of the David in opposition? Oh, Mremono. Bibi noa, bibi evidence. Chira uswe affidavit. Now saying na abeye evidence. Udi kutu uneko file court pe eka court evidence.
Asempa
affidavit in opposition say nsemne yebisa no o mama ya no sese no no ka kire nwomu say affidavit na question na mde aba no mu benya kwan ebisa emra mewo adaka no you see kwame obi there's a difference say mo baka say emra ma ho kwan say mu bebisa eni mu benya ho kwan ebisa. These are two separate statements. Bakun oka emran ho asem bakun oka ade a wo beyo or niebe besie emran Ghana mran so no deal with reasonable mind Ghana mra and deal with obi onim nyansa pa and obi asebe onim nyansa kura enyo na Ghana mra deal o Ghana mra always no deal with ordinary person dey nanka ordinary person me intina obi kum nipa na ya fa jury ni say jury say fun crofo mo potem one ama mehania wo ye no se mo potem hono nka yade etos mu ana. That is the essence of the jury, so that they will use your own standard while peers to judge a situation. So what was it? Together Mrano, it deals with ordinary people. Men who at your human son. Men who tell me try the brown no so jai me edu me so na me bekasa me yiwano. What can you do? Yes, ya new man train and yes send you a review. And a review no so no. What say beka the same thing that me say me ba edu me so na me bekasa me den.
Ekosiisen on Asempa FM.
Reasonable person biano. Beti me jina we so akase sadia. Na me close me masam ne close a. Ensem bebre sense maame no ni figures ne ekwa enko interrogate ni figures ne de court ni figures ne see mistakes wo ono no aye declaration ba ko bi enu miensa ye hu etiri hu enan enti sadia ye betwa mum no no ba daka no aye dan ye bisa no enti si di ya hodin gina so send obro no beka se if we relied on it ya ansore ka can rely e sign affidavit within simple no a e kire se obeba de kanum ntino ene gina so me close your case na bi nso kata no say ye see di nipa num ne baba ye di mienu ba kra court no ma ye ho kwan e bisa biom say mo ye ka se enum ye na nso ye kan interrogatories mu no ye kan say enum na ye de be kono ye de ba no. If we have gotten answers to some of the interrogatories, it would have informed our petition going forward. So what must say? Okay, say even one judge,
Ekosiisen on Asempa FM.
A radio baby omka say kotuampa no sorry yeah argument say they will have the opportunity to do it in cross examination. When we now hear argument if you are going to take the records of the court. Now change some lawyer for you so opportunity to home betima kan abisa court no even one judge beside that say tatu na denti na ontwen o pese o kire say ye nya ho kwan embisa cross examination na tatu so say mo say because that was the review court na dismiss your questions no only for say maame you rely also omo even say it is irrelevant.
Irrelevance was one of the reasons.
We see a irrelevant now. Irrelevant cross examination. What is irrelevant is not admissible in court. What must say? Our reliance, say a dinner mamina dianosno, has a basis. And when you so see a dinner so. Say court ni enya dream. Almost nothing around your court to real court case no. For years. The position of the Supreme Court and a unanimous position, now your wrong position until JB
Ekosiisen on Asempa FM
issue now. At the end of the day, and no better than you put it. Even though that time no court to argue say it was a wrong position. Today, what is the new position? Is it not the position of those who are against it? That is one. Miriam, what can I say? Ye argue your first case no. Yamfa section 722 amma. But that is why the per incurium came. Because call for reviewer. You go with new facts. Sorry kaka me ko review na unia sam dada na kan no. Eno ana wo kaka. Adintie ma ye call review ye kan say. One of the issues in say Supreme Court equal to black dictionary.
Black law
dictionary. Black law dictionary, no, according to our understanding, is the definition no, different from what is in section 72. Because what's black law dictionary, no, and we international law. What we are saying is, if you have a local domestic law, and it is clear on an issue, you don't bypass it and go for international law. So wow.
Ekosiisen on Asempa FM.
Na samra no. A deal with bibia. You don't leave your umra no. Na why then? wako international law. One of the definition of them are adverse witness. TMA. Almost say adverse witness, no. The person by Black Law Dictionary definition, no, the person will be in the witness box before the person can be adverse witness. TMA. So when you look at our Black Law Dictionary, you know, one of the definitions it gives is that a witness who gives negative evidence against the party, who call them as witness.
Yes.
So it means you must first call the person as witness before the person, when he start giving negative evidence, and not why, so and then you inform the bench, man, I want to treat him as adverse witness. Then your line of questioning will change. But in our section 72, that is not the definition of adverse witness.
Are you sure?
Oh, my brother.
Because
I'm
also
going to read it. Where
in the process
of
giving evidence.
Please give me where you read. Give it to me.
Okay.
I just want to open it.
I'm
reading for you, please. You relax. Oh, the man, me kase kasa. Me see be mama. Because we who minimum star. Who start here now do who be. Me see me kase. Who dey be mama. Because our understanding of section 72. It's different. Oh, the man, what is your problem? Mankind.
Okay. In the process of evidence.
The correct
one. Okay.
The correct one.
Okay.
The correct
one. Me too. Subject to direction of the court. In a civil matter, in a civil action, a party, a party or a person whose relationship to a party makes the interest of that person makes the interest of that person substantially the same as the party may be called by an adverse party. May be called not when he is in the box. So even before you are called into the box, you can be addressed as an adverse witness. Have you seen the difference?
Okay. No, I'll come to that. I'll come to we'll come to that. Don't worry. We'll come to that. I'm making an I just want you to know, sir.
Okay. Into our position, sir, our domestic law allows to call a person and even describe the person, sir, or your adverse witness. No, before the person entered the box, no, it's correct. That's by the law of this country. When you raise here in their ruling, almost say the black law definition is the same as our local law, even though we don't agree. We don't agree because I've shown you, say, I can refer to you as an we are adverse witness and Sanakrawa then we were boxing. But let me read it from black law, and I say, what the can into a to Salo, Nessidebi. Munko tula munjele when a paying kurium no buy no. Say you have no advert your minds to this fact. So at mercy. Now, let me address where chachu ko ye documents no. Baby chachu ko tu we no. Chachu ko tu we in support of the argument I me say no. In defining who is an adverse witness or who is not an adverse witness. But what was the application?
Ekosiisen on Asempa FM.
It was an argument to open our case. Number one, in this who read this section 72 here, or say you can call that adverse witness only during presentation of your case, not after. And that is why. You decided, sir. Because your name said that is there, it may be inadvertently or whatever. Your name said Ohunti. That is why we didn't go to court to challenge, sir. Challenge, sir, whether it was we want to bring the woman. We rather went to court, sir. On my inquiry,
you reopen your case
so that we can satisfy. Sir,
in the process of evidence,
in the process, because once you be a case, then you can bring in new evidence. So in court, no, ya nko si e kofrema mi no.
It was first
say you were from say why? Because we didn't go to say we are bringing the woman. You could say you could be a case. So that satisfies this. So my brother, whether what he wrote is what he read in court. If it was taken out, he does not change the law. And changing law, no, it's not what we say. It's what because Supreme Court. Oh, I don't know, Mamen Kasa.
Nana Manen Kasa.
What is that 45 minutes? And so, Usum Contom Providia, Usum Contom Providia, you cut at and your phone. But
Manen Kasa, Baba.
And in the American say, Semikoko, Namiko to law cry. It is not about what you go to, it's about what the Supreme Court. They will make reference.
Yes.
They have all the books in front of them. So
but based on what you quote, and they determine, and I say, influence the kind of argument you will do. But the argument will be contingent on what you quoted.
Not about whether it is in the course of our evidence to call the woman or not. The evidence was about the adverse witness.
Yes.
As to whether you can call an adverse witness, when does the person becomes an adverse witness? That was the question. The black dictionary quotation.
Say in a box ni my evidence now.
And a law to not just say even before we to go box no, what me friend adverse witness.
But you have to complete that definition there before that is you make sense of the entire provision.
You see, when you look at that definition, what definition there, it does not really go to this argument I'm making. To me, I can read all to the evidence by the party calling the witness. In during your presentation, I make say, anything that you really went. Young court say, yeah, we rather went to the court. The argument we're doing, the application before the court, was a review for us to open our case. Because it is only when we open our case that we can do what? That we can do the presentation. So that argument, even though the Supreme Court has ruled, we don't agree with them. Now, let me come to another point that is very clear. Section 26. When a person can be deemed, say, why conclusive presumption. And until I see it me day.
I rely on
it. And then I make sure say position of the law. No, you see, there's a difference between stating the position of the law and expressing your interest to comply with the law. These are two things. So one must say, and the meaning what can say. Now I say, the law says that you can ask ABC in cross-examination. That's difference. I will make this. You have the opportunity to ask this when I am in the box. These are also another position. In two applications, in affidavits in opposition. Na mami nankasa be can say, you have me opportunity business me bad that kind more. Waka first one, waka second one. At a point, even Supreme Court judge bisa say, "Ana we so bet me bisa o." No, judge say yes, you bet me bisa, but say no, what we are fighting say no. And yes, you bet me bisa na into me bisa, but the relevance of it because muruli mungunzo no relevance as them. Do you understand?
Yeah.
So we all concluded, even by their own argument, say, "My minister obeba that me bisa, you bet me bisa." But the question now is whether those questions are relevant or not relevant. And when another do fight say. You cannot say irrelevant. Ne. So when you can say you're irrelevant, dear, and your cross examination cry be saying what must say?
But how about the court's ruling and the court's point say those affidavits in opposition now, I mean, swear to they were for particular applications.
That is
interlocutory.
That is
any bearing on the main issue.
Clear in the law. Yes, we don't agree with them. Because you see, Okokota, you build a docket.
Yes.
The beer over Falibia or docket no. And every docket over Falibiana is part of the records of the court. Say, case, or every lawyer or court name say, when something is on the file of the court, at every point in the course of the case, you can
rely on that
leave of the court to make reference to them. TME, you can seek leave of the court because in practice the convention of the court say so people read the law because court some you have to ask permission. My lord, with your permission I read this, or with your permission I quote this, and I'm one. So the same thing you can say, my lord, with your permission I want to refer to this because it is part of the records of the court. I don't want anybody to tell me, say, the position of the Supreme Court, say, once any statement you make on affidavit and sworn affidavit, say for a particular application, not a delivery application, you can come back against it. Is that what you are telling me?
At least that's the understanding I got from the court's ruling.
So that is a wrong position.
Really?
That's it. That's my understanding of the law, no? Because Obi, send no wajuma uyenwahi. Nasa semaba ho. Na wo swear affidavit on some issues. Anamebwa. Na affidavit ni file o court. Na nye say ebia those facts no a change. Ana ade na a change ya. Ino ochina. Usanko ka asem foforo. Swear no on affidavit ne different from those who are intimi facade when metros and now can say what is the difference?
Me can say at the time in response to a particular issue I would buy. See how the issue about something different.
Listen, I've told you that once in my preamble, because when the issues have not changed, because the issue about the witness statement has not changed. It is a fact, it is a fact, so no sign.
Yes.
It is a fact, and the lawyers in their arguments admitted it can be asked at the cross examination.
So no the witness statement, only any affidavit in opposition to that particular application, different from the witness statement.
How can that be different?
What
reference were you making to? What reference were you making to? It's not a reference to cross examination. It's not cross examination we are talking about. Why do we want it? I don't think it's not for the purpose of cross examination. Cross examination thing here, no. Now, so no can someone in the video say, or Baba the can near realize so near cross your case. No, Castle Omar. We have every right to request, sir, Omra. The Supreme Court has the right to say no. We don't fight them.
Okay.
So what must say? So I just want people to understand, sir. Our position has not changed on the woman that we think that she must be accountable to the people of this country. That is one. Two.
Now what do I know?
Una your host.
Baba, now what do I
Una your host.
Baba, end in 1 minute for me.
Our position said she must be accountable to the people of this country. Has not changed. Two.
Ekosiisen
our position said we disagree vehemently with the position of the Supreme Court. No, has not changed because we still believe that some parts of our laws have not satisfied the issue the way it should be satisfied, especially section 72
okay, of the Evidence Act.
Now, can be about the subsidiary and this thing. Why do you evidence act?
An act of parliament.
Act of parliament. So that comes directly under the Constitution. The Evidence Act can be beer. And the Evidence Act on presumption, conclusive presumption, was clear. So it can be by his act, or disposition, or his actions. I don't know. That's on by the first time.
Have you considered?
And then no, first thing say because
the opening statement.
It doesn't matter the opening statement. It doesn't matter.
No, if the opening statement
what matters is that
instructive, it matters.
The opening statement that he said that in considering other laws,
yes,
does not take away the rights of the substantive law. It does not take it away. Unless you don't find it,
you cannot construe that provision without recourse to other laws.
in CI 16. Okay, say we have me Rule 5.
Finally on Rule 5.
Where no provision is expressly made by these rules regarding the practice and procedure which shall apply to any cause or matter before the court shall prescribe such practice. You see, the court shall do what? Prescribe. But when the Supreme Court was giving its ruling, the ruling before this, or say their jurisdiction is limited. Where the
relative
law,
to 64(1).
Yes, where the law is substantive law, like the Constitution speaks, whichever law that you come, unless you can't find that in the law, you don't rush to it's a secondary law. And when the so you can't prefer a subsidiary legislation over
an act of parliament. Baba made that say. There is one here from Abdul Malik Kwekuba. Say, Obi, ask Baba. Do they have their own independently collated figures or results? If yes, could Baba kindly provide them for the public and not the court's consumption? Or say, Meba. Their case sounds pathetically inexplicable. I think they need to take a flight to planet Mars to litigate their petition there. Haba. That's Abdul Malik.
I'm not surprised. I'm not surprised. Tell Kweku to go back to our petition and read it well.
Okay.
Let him read 14, 15, 16, and 17.
Paragraphs.
And
14,
if he
15,
reads
16,
14, 15, 16, and 17, when he reads that, he will now appreciate what we took to
court. Thank you. Yes, Nana B.
Unim say Baba ama omasem no kra no asa ayebasa ti. Utimi ka kire me say ebra na mo de sa application application by for reopen. It me evidence wo no say mo yimfrim anya say be say mo case. Oh, na say ma okay. Edi by inference obi to want it. Because is it there now? Oh, Obi, the law as provided, right, cannot be applied selectively. You cannot tell me say law no word boom and statement of case. Oh, me patrol. That's my okay. You also be our canon. That you oh the
in terms of the adverse.
And I make a say. It is because this particular adverse witness, no, who bet me yes, ha, when Nippon who conduct two case.
Oh, ask yourself.
Oh,
Baba,
if that is what I'm saying. Say they misled the court, but Nyamyeni Mukwenye, Utimi was animal before Fakutampo and himself before say Obedada Obidabi. It's your own part or no say shooting itself down. So I'm okay with that. So no idea to say no money say argument I don't know yeno. Because of European. I didn't say what the presentation of evidence ni betuma. I just say we conduct two cases and you know say cleverly almost the evidence ni film. Now more masem na ide. That's what consider this. Section 26 no. I am surprised. Misinia. Somehow okay. Are you telling this huge platform say CI enyemra me patombo CI enyemra.
Okay.
Because when you emra egu enu nya CI so nkwan kuta. Obaye emra kuta nkwan nya CI so.
No, but he admits that CIs are laws, but they are subsidiary in relation to another parliament.
That is what I'm saying. Said the opening paragraph of section 26 no, it opened itself up for other laws. That is why I make us say no, the operational sentence except as otherwise provided by law.
Except. Yes.
Yes.
Otherwise provided by law.
And even including rules of equity.
Okay.
What you say?
Okay.
Yeah, in the make us say we no more use with order 38 rule 3E5. Because court no so to say order 38 rule 3E5 no say o file witness statement no one rely on it. Any party can rely on it as hearsay evidence.
Hearsay evidence.
Good.
Yes.
So in their argument, they are of the view said there be any question ka court ne fan say once a maame no elect say any ade oba you see evidence bia no. So in this case the witness statement no, it is not even evidence before the court because also court tandakam nanka wa take oath. Then the witness statement no you better tender through or no. Na ba be evidence before the court because or elected not to adduce any evidence on mounted box on it no. That witness statement can be used by any party as hearsay evidence. So, in their view, I didn't know also court AUC rule or the 38 rule 3E5. Now, rather, no, the conclusive presumption section share evidence act in court name use one. And I make us say court will be on two fronts. Number one, except as otherwise provided by law, no, it can be in itself to apply any law. Fortunately, CI 47 as amended by CI 87 AMRA. It only have been defeated flat. Secondly, you have not demonstrated that you relied on Mamen affidavit. No. Oh, me pacho. No, oh, as a man, okay. Because what can I say? No, Bossu Bana Major Pie. Because so no. Obe catcher say wa asema wo ka no e wo se chinchan wa me be tanda kam ana wa asem no aye pepepe na ona wo ma me nanu asem bi o kan no wonya hotoso wo so wonso asem wa kan asem awie wo dia ko review abagu. What is important ne ma me ne kan no eno nyemra ne court kan na yemra court and come bia in the ruling say, oh, the reason why we are dismissing this application is the woman will have her day in the box. Into meet me to no court ni jina nyama mi asaso or see in their view and relevant. Secondly, the matters in contention questions no answer bono. Thirdly, because enei under NDC abreso eye maritabri appear upon mu e de mra CI 99 by no they are unable to apply SRCI 47
because of the exigencies of time.
Exactly.
Baba's argument is yes, court na nkasa in their ruling say maame no akasa no mo de omo ho atoso, but they said say this is an affidavit that maame na swear an oath on. Once you swear an oath on an affidavit, you own everything in there, and it is part of the court record. You cannot seek to
look. And man say you cannot compel anybody to adduce evidence.
Yes,
that is a settled law. Again, nipa no witness statement no de buy no. So witness statement no. And they was a mono madance for a mo frɛ o mo mbebo trokan o ho no. Amanye yasem, don't forget say even in an answer we have already alerted all parties our intention to raise preliminary legal objection. And a court now so you didn't issues no. So don't forget say earlier on cramp na court na parties especially first and second responders or maybe kind am some sort of alert be say asem no kra no nya bia kra evidence bia de ba because masema mo kan kra nyina so nim. Look uni bibi law strategy ka ho. Lawyers for the petitioner no let you down. The strategy failed woefully. Because Afina, how can you tell me say when you case abra to tell me case section 72 no said there are certain rights we want to meet so within the time more conducting case no you can apply to the court now more apply to court maka so move here say bia ma me no enso be trada kam and I say move to me say oh NCC cry yen close your case all of these issues are within our right to conduct a case. It the court busa umpe mienu so. Now why would you to say there be a case in what conduct we evidence also the baby or their baby. When in actual fact in the woman's answer he had already indicated to you that you have not even demonstrated any reasonable cause of action. And for that matter, your case is vexatious, frivolous. It doesn't meet the legal threshold. What they can't catch on the data. It is a also we a legal strategy spanner. Also no. Mami say you to papa so and you don't dance here. And usually they compare Dr. Mahmoud Bawumia, the brilliant, the fearsome. Look, in 2013, a year Openi Mahmoud Otena da kem. Na se me say video no say twagu kwana ko video ni biom. Na wo hwe how wo si man evidence na. What we easy now to work on now kokom kura wo so. we easy now to wa wona kokombe wo so bepentem kwa na kokogina daka nim na wo so wadi adanse e no wetimi di ate wanim kakra na wunya general mosquito oba be gina daka mu tutu papa so nipa muzumo wini mo ba quarter yes yebusam entina Malik ebusa ne say uni bibi in the same evidence act say uni presumption of regularity good and no say obia emrama no kwan official person bia na adwuma wi there is that presumption say adwuma na why no project it me figures on right so when you
rebuttable
presumption so you rebut it with evidence so go to court with your own collected evidence then tell the court say mommy asema what can you the presumption is that nyama bia why be irregular but we also think say irregular for that matter this is the evidence yes you are there but to rebut that presumption of regularity but you don't say wo there ukutama me no na so no ne figures ni o wo dey we no asa dey say wa yem from so enti ma be correct no enti from so na nyen sunsuan so bia wo so the law acknowledges some action as yes law no esum champion to boss me wi law no sum say a regular performance of the duties it wa wo ba no and also we could tell evidence be a former na pai any evidence asawa any evidence atintenhuro
okay
any evidence a okofa opani pesa white betanda kam na onu so no ni se oba to was oba oh
nana for one see fa na baba
oba say dia
5 minutes
on manage time
to
was we go here me so ya oh eti who conduct two case we wa fe wo dance for me ensa ne opa bia ya ma rojo so aba na nya opa bia ya ma omunya adoma dance aba no close to case you cannot go back and come and rely on section 72 when you have finished conducting your case when you have closed your case what we was some
but court no so can say a settled law say party be at me seeking the leave of the court to reopen.
You must show or you must demonstrate there are conditions to be fulfilled. There are certain conditions. I also want to make catch a court and say, "Nidi kai adansi yesu kubi e baby ana won sanya nkan na mpokra anya sekeke anya se wo anya akwadworo na mu hwe se nka behu."
Yeah.
True. Yes. In this case, mun demonstrate say new evidence be amon saka anu hye ebesi samade na mu hia ne se ye mamu kwan na ma me ne mrada kam na montoto na no na azana bi open so no court busai ade potin be na mpesi e bi mamu afi subpoena no kra no they were even unable to firm it up and answer, oh my lord near wo yanim sisia ne say mu de mu bi maye na you need to demonstrate that munya evidence be
as a lawyer and so him say in the process of cross-examination, sometimes you get some evidence.
I don't have a problem. But when time when our cross-examination, you cannot say what close what case what close you know. Now person please it's a settled law. Make not kind cases ni natural. Cases out immediately where you what just there to watch moment. We open so we atta versus atta. The one am the right? Atta versus atta. Hold it that there exists some exceptional circumstance to warrant the consideration of that application. That these exceptional circumstances have led to some fundamental basic error in the judgment of the ordinary bench. Then that this review say me can we open review no more the ban say review no discussion here can yes that these have resulted in miscarriage of justice. In all of these things you are unable to demonstrate because section 72 amode ban yedi kan ka tell me say mo amoso mode ban no kra no yedi kan kra no mo sai akwakwo US be afirma you misled the court, you have not been truthful, you have not been frank, you intentionally omitted an operational word just to mislead the court. Now and also say a miscarriage of justice. And yes I ka tell me say even section 26 no so kra no as a mo apply kra no say who say unless there's another law be honum. And maybe you have not demonstrated that you relied on the woman's words.
On the woman's words.
It is animal and Baba.
Yeah, those will be the questions for you. Number one, and on the reliance on the woman's word in the affidavit in opposition. No, Obibeka say okay, if because woman in the affidavit in opposition, but you saw it,
yes.
Why then didn't you make an application to the court? Say okay, based on the woman that cannot. Withdraw your application. They are trying to cross examination. Then you prove that you are relying on his word.
Because in their ruling of the first application,
the
issue is not only about the cross examination, it also has
about relevance.
Okay. And we needed to prove that. So you cannot say you are withdrawing at that point when they are saying that it is irrelevant. So if it is irrelevant, please. If it is irrelevant, it means that you can't even access that cross examination. So that's why we have to argue. But I'm happy. We'll be the question. Be very, very intelligent question. Say in law and in practice, cross examination, you can use it to prove your case. Cross examination. Today, cross examination. I did me 2 trials for court and in cross examination. What to me you sue and also the other day. Make your case.
Ekosiisen on Asempa FM.
So why your case? No, because member. Not because of that also can there. Because young close your case. When I have to know that I'm a law not here. Young close your case. Some opportunities here Becca say. Okay, young suspend your case no. Now yamma when that's a different thing. Now you see. Now, one thing I avoid, me say, once I may buy, make us say, now me no either lawyer bidding.
But I'm a person who address a presumption of regularity.
I'm coming. Also, about 15 minutes. On the end, I make us 15 minutes. I make you. What 15 minutes? And the net 6:45. I'm in free. And that's 6:45. I'm in free. Well, it is a what is the Okako, what offer books are going to can any become with them. And do it go. So, you make can say, send me ya mamba, not cross examination now. You be you which also allows us to also prove our case further. No, most of my mind, yes, cross examination. What are we going to do? In the Supreme Court, it stands as the law. But we are not again. It is the law for now. For now. But we are against it. Yeah. We don't agree with it. We don't know what will happen in the future. So what must say? But when the position they have taken, what kind of presumption of
regularity?
You see, we have a woman who has given us 4 different figures. See me, 4, and I'm going to mention all of them one by one. First, I say. The total 30,432,232. Obachi Beka say 30,119,460. Obachi Beka said 30,112,460. And at the last one, the bar court now is about 30,424,000 and 30,424,852. So 4 different figures of their mind, and no regular one. So we don't have a right as Ghanaians to ask which one is the regular one. Now your corner says Supreme Court near and money, no problem. We cannot argue. So what must say? 2. Mamino every declaration. By a declaration on the knife. And why you change why gazette at the on the 9th? And you have no gazette, no, which was gazetted on the 9th. And on the 10th, what the Abba say or the press release unsigned press release there, or they are changing figures, no. So which figure is gazetted now? Obi, this is ordinary common sense, ordinary or reasonable man. That's the word that law uses, reasonable man. In the same, one million figure on the 9th. And what the figure about change, what gazette, or gazette we know the press release about say, and also press release no about the new figures by you. In the same, 9th for the correct, and a 10th for the now sign and correct. na big boo baby o hana me de me ba mba se nkan na me bizanse baby a chi aboa no baby a chi aboa
no ye sane no
ho sane no entinka uye abato no wi no na the whole evening no ofro obi aba e ma obi abetra se wi na uye from 13 even that from 13 no gra no is a 41 no Oma political parties are all saying no. It is open so change then also.
Ekosiisen on Asempa FM.
This is simple common sense analysis. I don't know say. So francophone bi.
Okay.
No me na betrans. Now we are from 10 from. To say explanation why would they mind say what happened in Eastern region. Eastern region was mo your first form. Mo say mo jai concerns ba ko. The na mo ye mo san ko far from 12 foforo. And I'm saying here from Musu answer, I'm more hostile, and this is for answer. But at least you have an explanation for that. Remember, from 13 now, will be president lives in one sign. Party Ben Assam president lives in. So when we speak these small terms, no BS still we have not proved our case. Still no, the woman has no question to answer. Still no, mamini nye bibia also babu huwa kontamagana for. That's sad Supreme Court position to it. We don't have a problem for now. That is the law for now. But going forward, no, we don't know what will happen in the future. Now, another fallacy I have decided. Because I don't want to say member better as a lawyer. I speak about my colleague lawyer, even seniors above me say he's making sloppy argument, he's making wishy-washy, or I go and mention somebody's witness and try to ridicule. That is not part of our profession.
Okay.
So what must I say? Okay. Lower, if you are talking law, speak the law. So be cool to be now say wrong. At says no matter say you attack the law. But please don't go to the personality of the person. So what must I say? Because I'm running there clear. It is clear, sir. Our domestic law has a different meaning of adverse witness or who is an adverse witness. And now, Supreme Court quoted black dictionary law. And it's a black dictionary law, no, it's an international law, even though applicable here. But once you want domesticated law, you want law, and no, so am I in the same definition, no? I will say we have to prefer our law above that law. Also, when you see a law, no, a sin in the open, your law no said that, you know, because one of the things I no can say, advice in the true quad that can once one another, according to the black dictionary. Yes, you can over to my armor afro obi, say me here one. No, me say Uba, me no myself no back at me. My Lord, I want to call him as an adverse witness, even before you enter the box. That is what I have quoted for you here, Makotua. Actually, now, almost what I'm say. Supreme Court phone beside say, I didn't episode beside mamma. Oh, my brother, Corridor, affidavits. Should you have affidavit? Because you can't take, you see, every application must be accompanied by an affidavit. That's the law. Every application, unless it's there's a different provision for maybe other things. But say application will go before the court. I will say it goes with affidavit. Affidavit, based on the facts as stated in the accompanying affidavit. In the motion now, in addressing the motion, a motion it just states what you want. But the details of it, no, we now affidavit no. Well, the things that we wanted to ask her, it included the different numbers that she brought. We stated it clearly. It includes the affidavits. Now I day. Press release or the best when it has borders on CI 135, and all those yes, 13 years baby so because Sabina no cranian I wonder whether they read our until some baha midi petition no baha me yinu baku na man for kwasi yen fa figure bi abai enu me na kwaku baku ye no kwaku baku see any figures yen figures na figures ben the figures go god And the matter be go read no read be who near court. So that must here. So who near court send me some message obium. Because he must first understand. And that's I don't want to believe that Kwaku doesn't understand what is before the court. I don't want to believe that. Because himself he's too open-minded to the extent experienced to the extent that he will understand what is before the court. What is before the court is not our figures, and I am repeating it. No court many figures. Go read a petition, no a DNA court. So that when they are asking such questions, what is no be saying? When I match to catch will be say irrelevant no. So question will be an irrelevant question. The not discussion before we know. Everyone go back on Chassis. So that's a part of the question. My turn be on Kuri. Uridia. One for that question. Finally, before
messages we were Obi today the Supreme Court is telling law students that there is nothing like hierarchy of laws. Sadly Nanabi agrees with that. What then is the relevance of the structure of laws of Ghana under Article 11?
That's right.
Article 11 lists our laws in order of hierarchy. Obi, I dare say the Supreme Court is destroying. Okay, that's not fair. Confidence our central tone and the way about. Abdul Malik Kwekubako comes again. I'll say, do you believe this mythology of 4 different figures, confusion of thoughts, from 13 was or is a faulty one? I can't believe what Baba is saying.
Yes, because he's not following the case.
Abdul Malik
Supreme Court must.
Hey, we're sure.
I'm telling you, if this is his position, he doesn't understand it. So if you follow follow Nyako Supreme Court now, at a point. One of the justices, even from time to time, any evidence or the chairperson white, no any evidence. So okay, scenario, and the person white can say, this is not the standard from from 13, as prescribed by 127. 127 I'm kita why. 127 actually the type of form.
CI 127.
CI 127.
Now say go further and check. So.
But that is anything else cross examination,
no, me can't Pesa White.
No, because Pesa White that when he said that, no further questions were posed to him. But you answer 2 questions.
2 questions.
They showed him that Pesa White. Is it the CI 13 we are talking about? Oh, you know, this is not the standard CI 13 we have.
According to
CI 127. It is a combination of further questions on later. And now, what type of CI from 13 will you see here? Yes, so you see, all these questions are things that are waiting for her. And go and read, already your petition, your affidavit in the review. No. He will not be talking about mythology.
With the point.
And in any case, he's talking about Okam mythology. My brother, what it means about these figures that I've given you here? Are they all no figures coming from the electoral commission? Now, petty Ebahano 1450 quote to me reading Wahano. Didn't you the figure various figures? Has he seen the difference between what he declared in 9? And if Kwakubaku is talking, I'm sorry to say, but Kwakubaku is not following the case, or maybe he's intentionally doing this because otherwise, I shudder to believe, say. Until your constituency, and actually the only
his other point yes, you've made a point, sir. You did not take your own figures to court.
Yes,
but he argues, sir, in the public domain, you've stated before, say you won the election. By which figures? At least put those figures out to the public and not to the court.
I'm not here to talk about what we said in public. I'm not here to speak about that. Why is Kwakuba going to do this to himself? Because he's a seasoned judge and he shouldn't speak like this. I'm not here. We're no from the public assembly. And I'm not in the public assembly. And the side of public assembly, and the near McMahon can say, you be a honey, you be a padua, I know how some name Makaha. And I know on Tiano. You see, that is even one of the issues that journalists like Kwakuba should be worried about. Sir, the director of election of MPP say, and this is say a party almost a party, and it is a sort of worry for him. And he doesn't think, sir, I was thinking, my now he is what? she's interrogated on even the pardon. Because the two sides, both the petitioner and the second respondent, in the public has admitted, say, pardon or anamibwa. So if there's pardon, now you're backward. It's one of the issues. And in fact, it is one of the issues that Supreme Court are tuning. That is issue 5. That whether or not the alleged
pardon as complained by the petitioner
and errors complained. So we're talking about errors. Kwekubako, listen to me. We are talking about errors. We are not talking about our fears. We are talking about errors on the face of the documents. That is what is before the court. Here can errors what the face of the document. So say Uber, necessary journalists like my senior Kwekubako say your figure. What? I mean, is he also thinking like a serial caller? I mean, that's not fair.
That's also not fair.
No, it's not fair to you. No, the question she's asking, I shudder to believe that. Because I don't believe this question will come from Kwekuba.
No, is it not because you went to court under Article 64(1)?
To do what? To do what?
To challenge the validity of the election. That's
and
what
so if somebody declares a wrong election, is it valid?
How do you prove wrong election?
That is what we have taken the figures. We have shown the figures.
Because the wrong election will be the fact of the election, the vote people cast. You are not challenging any of those.
But we have challenged the pardon. Because we are talking about votes people.
And is the pardon substantial enough to have an effect on the results so declared?
How do you know?
That is what you have to prove.
I said that is what part of the question the woman has to answer. Because it is her figures.
The pardon?
Oh, yes.
The pardon is not her figures.
It's her figures. Not the figures.
No samples now, but the buy.
Those samples, yeah, these samples no be confronted because, for example, 13 constituencies.
Yes, but those constituencies were not declared by the woman.
The calculation was wrong.
Those constituency elections were not declared by the woman.
No, we don't declare constituency presidential election.
Absolutely,
it comes to her.
Absolutely.
So if she has used wrong figures, one recalculate, no, they are not am I in wrong figures. We have no right to ask.
And
what you are telling me?
Issue 5,
is that what you are telling me?
Are they material to have an effect on the result?
How do you know until
you have to prove it?
Okay, we have to prove that. I don't understand. We have given the figures.
Yes.
We said these are the mistakes.
Yes.
Our witnesses have come to confirm that this
yes.
some few mistakes.
Yes.
Of course, witnesses. Oh, one thing I'm voting is a witness cannot speak about the whole case. The witness speaks about what he knows about the case. And you can witness or bad that can man you need no can. And that's about the can sad message. And this a me say ya kayasem. Na ma me say questions are moving because question is about her anyway. The errors in way is about her. Onunkwa no betimi aka kire en say identity and figures now or declare on the 9th no or changing on the 10th. Onunkwa no betimi aka kire. That didn't figure no or changing on the 10th for no crano or backward no or the wrong figure at our backward. Who can answer this question? One bit my you know. Or no one the only person bet me here no.
But who say
and I know the bit my answer. The bet say mistakes or figures room.
Yes, and what did the mistakes do?
As to what it did. At the end of the case is where you know.
No,
because no.
But that is why you are a petitioner.
No, Timmy.
It comes back to the presumption of regularity.
For example, we have 4 figures.
Yes.
As at now, no, minimum figure constitute CI 135. I don't know the figure. Even the figure 135, CI 135, and the prima facie
evidence here for now.
Nana being president. But I don't know the figure. Because so far, no. Figure now.
The figure is on the Form 13. You don't. It doesn't have to be stated.
Which Form 13? Which Form 13?
Which Form 13? Sir?
Yes, which Form 13?
The Form 13 used to declare the election.
Where is that Form 13?
You don't have a copy.
We don't.
Because your rep was not present.
It's not about our rep being present or not. Even what she evidenced in court herself. No one the back court. Yes. There's a mistake in it. How do you explain it?
How do you know there is a mistake?
Because we have compared it to what is in the law. We have compared it to what is in CI 127. We have compared it. And when we compared it, this is one here. This is Form 13. It's here. What is supposed to be done? Form 13 is here. So if you have Form 13 here, now no akoye form bia. Because you can't Form 13.
But whether it is the same thing here or not, the court would have to decide, not you.
And who will come and because
the court has the benefit of seeing the two.
No, you see, that's where you are getting wrong. The court doesn't get involved in the case. The court listens.
No, since you're not closing the case.
Oh, hold on.
The court is now seized with all the facts.
Hold on. How are they seized with the facts? How?
They've also closed the case.
Listen. Form 13, Form 13 is one of the controversial issues. One major, because it is the Form 13 number 1. Young signed. Form 13 you say mistake womb. Form 13 you say figures are what no. Yababe changing on the 10th. And these are questions weighing now. And enough for na maame no essence ye ni Form 13 inti. Ne empathy yabaga ko forgery. Yam evidence. Yam fan kokko.
Yes.
And the mammy no di and why they
or the no about
the abase but the Bible prove say
yes
declaration am here
yes
I don't know ya kaya say me do baby
and I'm calling on the court say court ni CI 127
no but
and no miss our form na nye
when person why say
yes
that CI 127 and standard no because it was not in evidence it was no question further to me
yes
because it was a high court it was Supreme Court judge
yes
one of the panelists and all the children. Look at this form. You say you don't have Form 30. Take this form. Is it not the Form 30? Evidence by Electoral Commission. And I'm but why to hear not this is not you don't think that is enough reason?
No, but the point
you don't think say the fact say the final form that law no come
yes.
Obi allege say and you're correct. Me no say you are allergic.
Yes.
Say and you're correct.
Yes.
Inti mami emi hila no ho.
None of mami no prove say and you're correct.
Me no be prove mami.
So the court why it is not correct.
Me say no because you see Obi.
Who say and you're correct based on CI 127.
It is sad that
the court is now seized with both.
It is sad.
The CI and the exhibit.
Okay.
Which is from 13.
Yes.
So the court will compare
so we are saying that it's not correct.
Absolutely.
And that is what she used. So it is for her to come and say it is correct before the court cannot take a decision. You understand?
And she
hold on.
She will not leave evidence. The court can decide based on no evidence.
Yes, the court can, you see, that is where the problem is.
Why is it a problem?
It is a problem because, in our view, we have not been given the benefit to, in fact, prove the case beyond all reasonable doubt.
But that is a problem.
It's a problem.
You don't need to prove your case with the woman.
You see, you yourself, you are contradicting yourself as a law student. You know, one can say you can use cross-examination to prove it.
No, if you don't get that opportunity, you don't get it as a matter of fact.
You said it.
Yeah, I said it. That's true.
And to say, if we have alleged pardon,
yes,
alleged errors, we have proved the errors. We have given 4 different figures in our petition. We have shown how Nanado didn't get the 49 point.
The 50 more than 50%. Yeah.
Nanado had 49. Nanado now 49.625. You prove winner. As Ekosiisen say no. There are a lot of allegations in our petitioner which has not been challenged. You're challenging.
Yeah.
So who is supposed to come? For example, what is the status of Mameno witness statement? What is the status?
So the lawyer can say it should be treated as a hearsay evidence.
Who will treat it? We have not selected to treat it. Who will treat it?
Of course. So if you are not selected to treat it, it's there.
It's there for what?
For what, saying?
Because you can't just put in anything in court.
Yes.
We must know the status.
Yes.
They should either,
Ekosiisen
if they say they are not prepared to do it, then they should either
withdraw it.
Or the court will strike it out. But both have consequences.
Yes.
Because the moment you strike it out, let us say all their evidence will have to be struck out. And our petition stands unchallenged.
Yes.
So they will not do that. And then I make we may say, I didn't know we withdraw on witness statement. I didn't know they will not strike it out. because it has consequence. In the witness statement, so the court in court, you don't deal with an issue when they are hanging.
When they are hanging, but with the court now, to your advantage, take a decision based on more evidence. I'm going to court, and that should be.
We don't want the advantage. We want Ghanaians to know the truth. So that advantage you are talking about is not an advantage but the truth want to exercise.
A truth leading to you
want the woman to come and tell the whole country at the end or declare 4 different.
You don't want to win the case in court. We are in an adversarial system.
We want to win, but that is also another misconception about our Ekosiisen. Yes, we are in an adversarial system.
Yes,
but it does not mean the law allows you. Otherwise, the whole issue of discovery in the CIA 147 will be useless. Even though we are in an adversarial system, once I know can also my prelims. We'll be sending message. We say now. The Supreme Court is the hierarchy of our laws. Now, also another aspect of the thing and that's the question I asked you. So now, are we saying that when there is a law which has a domestic, a law that is domestic, so we will now prefer international laws above our domestic law? No. That's also another question we need to ask. Finally, once you can say, your prelims be. You see, they forgot to say your prelims by me and sound. From the very onset, we can see you being here and you may be a female.
Those are not things you get as a matter of right. They are the court's discretion. You have to convince the court why they should
for example,
grant you leave.
For example, do you know that when I serve you, notice to admit facts?
Yes.
In the law, no say 14
Ekosiisen on Asempa FM.
It's supposed to be accepted as the position. But all this, we said mutual request to inspect. So from the very one time, we also didn't hide your intention. Say you been here, you may be if you mamma. So I know say from Berlin, yes, I wouldn't say you may be if you mamma because. From 30 years, from say any questions, results now can go. One of the results, one of the questions is 4 now they are ban.
Now from 13 and more original. No.
Of course.
It is not within your right to get the original. What you can get is duplicate. That's what the law says.
We didn't say we wanted the original. I said that we were going to inspect the original. Go and read our petition, our application and affidavit. We said we inspect them.
You wanted to inspect,
and then we permission to make photocopies. Okay. We didn't say we wanted the original.
Right. But the law says you
I'm
have
not surprised.
to give
I'm not surprised. I'm not surprised about Obi. I'm not surprised. You see, if my big brother like Kokubagu is not even reading the things and asking such questions, I will forgive you. I'll forgive you. Because if Kokubagu cry is not reading the things and making this question, I'll forgive you.
If the law says as a matter of right, you need to be given the duplicate. Why don't you go ahead and request for the duplicate? Why do you have to go and inspect and when it becomes necessary, you get photocopies?
You have 4 figures coming out. So we need to see which one is the original, so that we know which figure we are working with. Is that too much to understand?
Lawyer Baba Jama.
Is that too much to understand?
Former MP former Deputy General Secretary NDC, and one of the spokespersons for the petitioner in the ongoing election petition case. And in future, he would go back to Parliament. Mebwa.
Oh, and no Parliament, but I'm not going to this.
That's it. Mama Jamal and the tuning. Ekosiisen is in the higher Asempa 94.7 FM. Okay, Baba, Chairman General Kwame Sefa can so chiao. Ekosiisen is in Mama Yentie, this is a song Mete Papa, ya sapon.